Good afternoon, and welcome to Under the Microscope, Strategies for Implementing State and Local Microscopic Hair Comparison Reviews. Thank you for joining us. This free webcast was made possible by grant funding from the Bureau of Justice Assistance. I will note, as always, that the views or opinions presented in this webcast and materials are those of the presenters or authors only and do not necessarily represent the official position of the U.S. Department of Justice. I'm Amelia Maxfield. I'm post-conviction counsel at the National Association of Criminal Defense Lawyers. I'm joined today on my right by Gant, staff attorney at the Committee for Public Counsel Services Innocence Program, Audrey McGinn, who is the director of the Iowa State Public Defender's Wrongful Conviction Division, and Farrar, who is a project manager at the Midwest Innocence Project. We've formatted the webinar today to focus on the aspects of starting a state hair review that are most daunting, namely getting started, finding and prioritizing cases, developing a protocol, actually reviewing the cases, notification, and representation and remedies. In addition, you will hear some background about the FBI Microscopic Hair Comparison Review, hear NACDL's recommendations for starting a state review, and learn what's going on in Iowa and Massachusetts, respectively. Remember that if you have questions at any time during the presentation, you can email them to Vanessa Antone at vantoun@nacdl.org. Okay. To start off, a little background about the FBI Microscopic Hair Comparison Analysis Review. This review is a collaboration between the Department of Justice, the Federal Bureau of Investigation, the Innocence Project, NACDL, and the pro bono law firm of Winston and Strawn. Although we are partners in this review, this is really the FBI's undertaking, and our role is to assist them in reviewing cases, notifying defendants, and finding counsel if need be. Hair comparison has been problematic for many years. In 2009, the NAS report specifically called it out as being highly unreliable. And our review began in 2012 following the exoneration of 3 men from the District of Columbia. Although the FBI originated this science in the 1960s, they testified all around the country in both state and federal cases, and also trained many state and local analysts, which we'll be discussing more today. When the review started, the FBI and the DOJ admitted that they may have introduced flawed forensics into hundreds of cases over 40 years. However, our review only looks at testimonial overstatements in lab reports and testimony. It does not consider the validity of hair comparison itself. And the results have been really staggering. We have found so far error in over 90% of the testimony we've reviewed from FBI hair analysts. We've reviewed about 1,500 cases so far. 26 of 27 testifying examiners have made erroneous statements. And in fact, the only analyst who didn't commit any errors only testified once, and he testified in the Joseph Sledge case. Years later, the hair from that case was DNA tested, and it was discovered that it was not Mr. Sledge's hair, and he was exonerated. And recently, we had our first conviction reversed based solely on the microscopic hair evidence as newly discovered evidence. That was George Perot's case, a CPSCS client, which Ira may mention later in the presentation. So our criteria for review, in order for a case to be considered for the FBI review, there has to be a criminal conviction. It can be after a plea or at trial. Hair analysis must be used, and we review both testimony and lab reports. And a positive hair association must be made. We do not review inconsistent conclusions or exclusions, and the hair testimony must be inculpatory, and we define that sort of broadly to be sure that we're including all the cases we should. And generally, we only review cases before 2000 when DNA testing became protocol in the FBI lab. Initially, Initially, the FBI identified 21,000 cases where hair examiners issued a report. Eventually, they narrowed that down to about 3,000 cases where there was a positive association between the questioned hair and a known sample. And as I said, we're about halfway through those. Our protocols, and first I should say that our protocols, took years to develop. That can be one of the most overwhelming parts of starting a review, and it was no different in the FBI review. The protocols were developed, and after sort of a sample review, looking through some testimonies, some transcripts to see what the errors were, and they were developed by independent scientists to reflect the status of the science of hair comparison. So under our protocols, the FBI team is the first to review a case. They find the case, they get the transcript, they notify the prosecutor, they review under our protocols and issue their results, and their review team is comprised largely of FBI laboratory scientists. After they make their determination, they send the case to us, NACDL and the Innocence Project, with Winston and Strawn acting on the Innocence Project's behalf, and we review it independently under the same guidelines and protocols and determine whether we agree or disagree with their results. If we disagree, we discuss it with the FBI lab in a phone call. If we can't reach a resolution, then that disagreement is noted in the notification, but usually we can work out our disagreements before the notification is issued. And then finally, the Department of Justice sends the notification letter to the prosecutor and last known defense counsel. We do not send letters directly to defendants unless there are no other options, and any disagreements are noted in that notification letter. And we're going to talk about this a lot at many points this afternoon. Our review does not consider the materiality of the hair, and when we talk about materiality in this context, I found that we use it in sort of two ways that I'd like to define for clarity's sake. First, we don't consider whether the hair evidence was material to the conviction, meaning we don't try to determine whether the defendant would have been convicted without that evidence. But we also don't parse the hair testimony to determine whether the inappropriate testimony can be severed from the non-erroneous testimony of the analyst to save that testimony. We just look to see if statements exceed the limits of science as defined by our review. While we note limiting language and disclaimers that the FBI gave, we do not consider them in determining whether a statement is error. So some key provisions of our review. First, the Department of Justice waiver of procedural defenses. The Department of Justice agreed to not raise procedural bars in federal microscopic hair comparison analysis cases. They will consent to vacating a conviction where it's clear the defendant is actually innocent. And recently they stated that they will not contest that the FBI overstatements are false evidence. The quote below is the strongest example of that agreement. And all of this is done to make sure that we can resolve these cases on the merits and get back into court to allow for proper resolution. And then finally, the FBI has agreed to do DNA testing at their expense in these cases of any biological evidence that remains. Another key part of our review is that our agreement with the FBI really it establishes the limits of the science of hair comparison testimony and the nature of appropriate hair comparison testimony. This is important because it was really the first time that was done in this discipline, and it's also useful for understanding and evaluating other pattern matching disciplines that rely on the same hypothesis. So I'm going to briefly go through the three types of error in our review. These are probably, this is not the first time you've heard about this. So error one, the examiner stated or implied that the evidentiary hair could be associated with a specific individual to the exclusion of all others. It's just your basic testimony that that hair came from that defendant. Error two, the examiner assigned to the positive association a statistical weight or probability or provided a likelihood that the questioned hair originated from a particular source, or an opinion as to the likelihood or rareness of the positive association that could lead the jury to believe that valid statistical weight can be assigned to microscopic hair association. It can't. That research hasn't been done. That kind of error looks like the quote below. I would say that the chances of it being from someone other than the defendant would be highly unlikely. And then error three, where the examiner cites the number of cases or hair analyses they have done and the number of samples from different individuals that could not be distinguished as a predictive value to bolster the conclusion that the hair belongs to a specific individual. Those errors they look like, I've been a hair analyst for over 20 years and only twice in my career doing thousands and thousands of hair comparisons have I ever not been able to tell two hairs apart. Okay, so we've learned a lot from the FBI review, primarily how prevalent the errors were, what the errors looked like, what analysts were saying. But one thing we've also learned is that state reviews are really important. If we're going to actually fix the problem of this flawed testimony, we're going to have to do reviews on the state and local level for a couple of reasons, namely because the FBI trained many state and local hair examiners for over 30 years. the FBI found training records this spring that showed that examiners from 48 states attended hair and fiber school over a 30-year period, and that only accounts for a small percentage of the trainings that were done by the FBI. There could be many more analysts trained in with these flawed techniques. And we also know from recent exonerations that defendants who were convicted based on the testimony of state hair analysts, those analysts made the same mistakes, the same erroneous statements that the FBI made. They committed the same type of errors that we've identified in our review. So we think it's highly possible that this erroneous testimony has made it to state and local labs as well. And so far, there are review efforts ongoing in over a dozen states across the country. So even though we all know that this is important, it can be hard to get support for this type of review, but there are a few ways to do that, and a few documents and opinions that lead you to believe that this is necessary. First is the notification from ASCLD Lab. ASCLD Lab is a major accrediting body of forensic labs, and they sent a notification to all of their labs in April 2013 saying that there was a broader need for review in state labs beyond the FBI. In addition, in February, the FBI Director, James Comey, sent a letter to all governors encouraging them to do reviews in their own states and of their own labs. Oh, and both of those documents are included in your materials today. So NACDL, we've been working with folks across the country on some of these state reviews, and based on their experiences and our own experiences with FBI Lab, we've developed some best practices for state and local reviews. First, we think it's important to partner with the lab and prosecutors if at all possible. Obviously, that depends on your relationships in your state, but the notification means a lot more when it comes from the lab or the state, and the defense function in this review is really important, but unfortunately courts listen more to the lab in the state when they're correcting their own mistakes. And we think that wherever possible, those partnerships are the most fruitful, the best way to do these types of reviews. Also, when it comes to protocols, we encourage consistency with the FBI error types, and we think that for a couple of reasons. First, for parity between the FBI review and the state review, and between states. It will mean nothing if at the end of this we can't compare data across different labs, different states, and with the FBI review. Second, our scientific standards and protocols were developed independently and are based on the accepted limits of science. There's not a real need to reinvent the wheel here. We think this can serve as a good base starting point for protocols in the states. And then finally, the error types can be expanded to include other types of errors that the FBI review doesn't consider, namely racial classifications. In addition, if you start the review effort in your state and you realize that analysts were making a specific type of error that FBI analysts didn't make, you can expand your protocols to include those errors as well. We just think that the 3 error types are a good floor, a good base for a review. And then the review team. We think that the error determination should be made by at least 2 people. Practically, it's just really difficult and subjective to try to figure out what is and isn't error, and so the more minds you have to that task, the better and more independent your judgment is going to be. We encourage the initial determination to be made by 2 reviewers, and then to have an independent secondary review by another 2 reviewers. We also think that discussion between those parties and across states is really important. It's really difficult to try to jump into this and pick out error, so the more we can learn from each other, the better. And then we encourage you to think about data early on. It's a big task to try to track all this data, and so have a plan for that from the beginning. We recommend that you track data and disseminate it regularly, both to your partners and to other people, and then think about what you're going to do with that data and how you're going to release it to the public. Materiality, again, we strongly encourage you to not consider materiality at this stage in the review. And we do that for the reasons I mentioned before, but also for a couple practical reasons. It's really difficult to know from the information you'll have when starting this review whether or not something had an effect on the conviction. It's hard to tell whether their evidence was at play when you only have a lab report or you only have testimony from an expert. It's just really difficult to do. And also, we can't tell the impacts that this testimony had on the jury just from the the transcript, that would be inappropriate to try to make those judgments at this stage. That's better left for courts later. We think it's best if you just constrain the question to whether or not the testimony or the lab reports exceeded the limits of science based on your protocols. And then finally, considering materiality at this stage is really inconsistent with the duty to correct. Labs in the state, they introduced this flawed testimony into criminal trials. They have a duty to correct that, whether or not the defendant was actually innocent or guilty. That's an accepted duty, ethical duty that they have, and only reviewing cases where it's clear, where it seems like the defendant is innocent would not meet that duty. Okay, and then, more about the duty to notify and to correct. We encourage notification of all parties whose cases are reviewed, regardless of guilt or innocence, and regardless of whether an error was actually found. And then also we encourage you to think about notification from the beginning. Who will be the point of contact? How will you communicate this complex information with defendants? What resources will you include in that notification? When will it go out? All of those questions that you should be prepared to answer before you start sending out those notifications. And then finally, we encourage you to try to secure remedies from your review partners. One of the benefits of partnering with the lab in the state is getting some of these concessions, such as free DNA testing or a waiver of procedural bars. You should see what you can do with your partners and what remedies you can establish from the beginning that will help you down the line. Okay, so now I'm going to turn it over to Ira, who's going to tell you a bit about what's been going on in Massachusetts with their review.
Thank you, Amelia. Hello, everyone. I'm going to talk about Massachusetts. I'm going to skip to the next slide for just a minute to give you an overview of Massachusetts' hair comparison review. So Massachusetts essentially has the state police laboratory, the state police crime lab, that's inventorying all of their records generated between 1980 and 2000 for both microscopic hair comparison or hair comparison associations or serology associations that are doing both. CPCS Innocence program, I'm just going to refer to it as CPCS, which is Massachusetts' public defender agency. CPCS has partnered with the law firm Ropes and Gray to essentially accumulate the necessary information to properly review these cases. And that is in large part because the CPCS Innocence program is myself and the director. And as you'll see at the bottom of the slide, it's a huge undertaking, and as you'll hear later, a huge undertaking to do one of these reviews. We also have partnered with the Middlesex District Attorney's Office, which is one of the larger district attorney's office in Massachusetts, in an information sharing agreement. Essentially, the state police lab has a policy limiting its ability to share information from the tests that it's done and the associations that it's made, because it can only release that information to the agency that ultimately provided the samples to them, so typically the DA's office, or to anyone the DA's office gives them permission to do so. And so here the Middlesex DA's office has given them permission, the lab permission, to share that information with us. So where are we now? What's going on with the review right now? So as of last month, the State Police Lab has reviewed 7,000 cases covering the years 1980 to 1984. I should say that these particular years were chosen because the records go back to 1980 and 2000, like with the FBI, was when the state lab started doing DNA testing instead of hair comparison and serology. And 2000 was also when they started computerizing all their records. So as of June 2016, they've reviewed 7,000 cases for those 4 years. I don't yet have a breakdown of those numbers, but to give an example, you can see that in February 2016, they had reviewed half that number of cases for 1980 to 1982. And for those 2 years alone, those 3,500 cases, 1,000 of them involved hair comparison or serology analysis. And of those 1,000, there were over 200 associations made. And so that is for all of the state that the State Police Lab covers, which is pretty much all of the state except for the Boston area. And so a portion of that is likely a part of the Middlesex District Attorney's Office. So that's where we are now. And thinking about how we got there, we'll just leave it there. I think it's important to a lot of this information Amelia already talked about, but this is really where it started for Massachusetts. The 2009 NAS report came down. The 3 DNA exonerations happened in D.C. that were related to the FBI's errors with hair comparison. Around that same time, in 2010, the CPCS Innocence program was founded. In 2012, the DOJ dropped its letter still explaining its internal review, the FBI's internal review. And then in 2013, you have the ASCLD letter, which directed it to all of the labs, which include the Massachusetts State Police Crime Lab and the Boston Police Crime Lab. So that was going on, and at CPCS, we were essentially starting where many people started. We just were asking ourselves questions, like what does this review mean? What does it look like? What are the local labs doing? How many cases could there be out there? And we just start thinking anecdotally about what cases we have off the top of our head or what we know about. And very immediately we identified 2 cases, one of them which was represented in part by the CPCS Innocence program. So we have Velasquez, who was not the person represented, who was convicted in 1988 and exonerated in 2001. And he was convicted in part based on a state hair comparison from a hair that was found in the victim's underwear, and they said that it was his hair. Ultimately, DNA testing on another sample proved that he was not the perpetrator. Michael Sullivan was convicted in 1987, and his convictions were overturned in 2013. And essentially, state hair comparison showed that, or their opinion was that hair that was found on the victim's, that's found on Mr. Sullivan's sleeve was the victim's hair. And again, DNA testing on other samples ultimately showed that that was not the case. DNA testing on that hair proved inconclusive as well. So we knew that those cases were out there, and we wondered whether or not that there may be many more. How many more are out there? So we, while we're asking ourselves these questions and thinking about how to start such a review, we essentially were forming partnerships in other areas with stakeholders in Massachusetts criminal justice system. In 2012, around the same time that all these things were going on that we're already discussing, Massachusetts legislature passed its first ever post-conviction DNA testing law. This DNA testing law made certain mandates about the preservation of evidence and mandates for the state police lab to provide guidelines on evidence retention. And so the CPCS Innocence program partnered with the agencies you see on the slide here, which include the New England Innocence Project, a couple district attorney's office, and a clerk's office to improve the way that evidence is stored, tracked, and handled in Massachusetts. And in certain cases to do DNA testing on evidence that's located through the partnership. And we created a working group and applied for a federal Bloodsworth grant. This partnership is completely unrelated to the hair audit, but it's important to note that this is where it started for us because we formed these partnerships. And our hair audit is based on the partnerships that we formed here, and the way we approached it was based on that. So we formed the group and we start meeting. And because the state lab has been ordered to do its own guideline development, they know that we're meeting and they come to our meetings to collaborate. They weren't originally part of the working group, but they wanted to start collaborating, so we started to work with them. And we learned, as you can see very early on, that we were able to make great progress when we essentially took off our litigation cap and thinking about things adversarially and tried to push forward policies and procedures and see where we can come to agreements about things purely on a policy level, and understand what it was that these different agencies wanted, irrespective of individual cases. And again, it was in that particular group's partnership was just to identify and overcome obstacles to find evidence and to create best practices for evidence handlers, everybody from police to clerks, anyone who touches evidence all along the way. So we'd formed those partnerships and we'd met with those people, and we decided that now was the right time to start pushing for a state level hair review, and CPCS reached out, their forensic services director reached out to the state police lab director and the Boston crime lab director, asking them if they essentially would meet with us to talk about the possibility of doing such a review and what such a review would look like. And again, we didn't approach it in any way of telling them that these are the errors that are going to be found, and these are how we're going to categorize them. In fact, we left it very open. We didn't shape. In our proposal, we didn't shape it in any way that this is what the review is going to look like. We just wanted to start the conversation with them. And the state police crime lab, who was the only one that responded, seemed very receptive to that. And so the CPCS Innocence Program and the New England Innocence Project met with the state lab's director, the deputy director, and their chief law enforcement officer, an actual badged trooper who oversees the state police, and met with us. And our goal for the meeting, of course, was to get the lab's collaboration for another grant, but if nothing else, to get their collaboration to do a hair analysis. And we went into it thinking about it from very, many different perspectives about like, well, what are their concerns going to be? What are their objections going to be? They're going to be the obvious ones about resources. Are they going to be objecting to doing any sort of review, because Massachusetts has had several reviews of their crime labs in the past several years, and we just went in with an open mind and talked to them. And ultimately, what the lab was very interested in were resources. They seemed very interested, of course, and we approached it from that standpoint, thinking they might be interested in essentially, proving the soundness of the science that the lab is doing today, right? Recognizing that as the FBI have, that there have been errors in testimony and hair comparison in the past. And they also were interested essentially in computerizing their old files. That was something that they were very interested in and making it a part of that. And as I showed before, they started computerizing their files in 2000, the same time that they started doing DNA testing. And so they essentially said, we could do this inventory the same time that we're going back through our old files and digitizing them, and essentially doing this data collection. So as you can see, it was a marriage of common interest for the lab and for the criminal defense attorneys. The lab wanted the resources to computerize their older files, and CPCS really just wanted the information, and that was really our focus. Again, we didn't go into this saying we're going to apply for a federal grant, recognizing that these are the errors that are here, and these are how you're going to deal with it, and this is how you're going to share the information with us. We just said, we want the information, and we want a way to compile the information because it's sitting in boxes on paper in a storage facility. And of course, the grant program, the federal grant program, has a common interest because they want us to identify cases where DNA testing can be done that could possibly lead to viable claims of innocence. So we agreed to partner a grant application to inventory and collect the information, and we got the grant. We applied for the 2014 federal Bloodsworth grant and got it. And again, so we have this one grant separate, the working group that's looking at DNA testing and evidence preservation, unrelated to the hair audit, and then the second grant that's tied to the hair comparison audit that is also tied to DNA testing, right? So if we can identify specific cases where hair comparison was done, that might also be amenable to DNA testing. And the collaboration, as you can see, was very much tied to the availability of funding. The lab wanted to be able to hire someone and to digitize their records, and we wanted to be able to get the information. As I've gone over multiple times, and as Amelia has a little bit, we haven't really nailed down all the details, not even at the stage that we applied for grant, and not even to this day, because getting the information was the most important, and is still the most important. Our focus was, again, getting access to the information. So after that step of applying for the grant, our next stage was thinking about getting collaboration with prosecutors and different prosecutors' offices. And again, what information should the lab collect? How should they collect it? What information, how will it be set up? Will it be, will they be just giving certain information? Then what information will they share with us? In our other partnership, we had essentially entered into an agreement with the Middlesex District Attorney's Office about sharing information and prior testing that was done by the laboratory. So again, we relied on looking at that prior partnership as informing how discovery agreements might work moving forward. We ultimately came to an agreement with the Middlesex District Attorney's Office about sharing information and the hair analysis as well, and in your materials you have the discovery agreement that we formed with that prosecutor's office. So here's what we know now while the lab is doing this review, right? The lab is identifying all hair and serology cases. And I should note, I haven't explained this at all. This presentation is about microscopic hair comparison cases, but we also asked the lab if they would go back, since they're going back and looking at these records already, to also look for serology associations, and they were on board with that. And so that's something to think about as you're forming these reviews, is it doesn't, depending on your particular state and your particular agency, you don't have to necessarily limit yourself if you're thinking ahead about additional additional work and additional forensics that might be out there that you want to review. So the lab is reviewing all of those cases, but at the moment they're only disclosing the associations that were made in Middlesex County cases. Now, Middlesex is one of the larger counties in Massachusetts with the county that covers Boston, that's Suffolk. Together, they are responsible for roughly 50%, or a little over 50% of the homicide prosecutions in Massachusetts. So it's a very large county and one of the larger prosecutors' offices. So it's great that they were on board, but we're, of course, looking for other prosecutors' offices to ultimately collaborate as well. But what we're currently planning and what we don't know at the moment is what is going to be the difficulty of finding cases and documents. Once we get the names and the information of associations that were made and hopefully learn very early on, or the prosecutor may tell us very early on which cases resulted in convictions, how difficult is it going to be to find the defendant, assuming they're not all in prison, or find trial transcripts, to really look at the testimony, to find lab reports or anything else. Will the lab do its own review? Will the prosecutor do its own review? Will they just be giving the information to the public defender's office and we'll be doing the review? These are things that we're still hammering out right now. And I think that that's a good example of the fact that you don't have to have all the questions answered when you first go in to form the partnership to get the information. As you may know, in reviewing cases, sometimes finding the information is the part that takes the longest. And you don't have to marry yourself, even from an adversarial standpoint, of what it's going to look like in the future until you get the information. So I'm going to talk about recruiting partners. So the Massachusetts, the CPCS has partnered with the law firm Ropes and Gray to assist us in accumulating the information, to collecting all of the information and the data as we go through and as CPCS begins its review. And one of the reasons that we reached out to Ropes and Gray was because they were co-counsel in the George Farrar case that Amelia mentioned. And that was all going on at around the same time that we were starting to begin this review. Originally, Ropes and Gray became involved with George Farrar before CPCS did, and then we all became co-counsel, and both parties became very knowledgeable about the FBI's hair comparison review and about the error types there. And so we had already again formed that partnership, and we reached out to Ropes and Gray and asked them if they would join us in this review effort, and they agreed. I'm going to just talk briefly about finding and prioritizing cases, because again, Massachusetts is still waiting on this data that we're going to be getting very soon from the state lab, and we don't yet know, and we're still formulating what exactly that's going to look like. But these are three pillars to think about. I just want to point that out there. You want to think about and finding and prioritizing cases, which ones to look at and how to analyze them. Is we want to base it in a great deal on the inventory and the data that you're getting from the laboratory. You can rely on your own existing case review protocol if you have it, or you can look to NACDL's best practices or the case review protocol that they've outlined that was done by the FBI and Winston Strawn. And then to some degree, and I think this is further down the line, you also have to look at the existence of evidence. And I think folks, Audrey and Summer, will talk a little bit more about that. Thank you.
So, yeah, thanks, Ira. This is I'm Audrey, and this is Summer. We're going to talk about our review in Iowa that we've been doing for about a year now. I'm with the Wrongful Conviction Division at the State Public Defender, and Summer is with the Midwest Innocence Project, and we partnered together jointly with the Innocence Project of Iowa to do our joint review. And our review is essentially taking place on two tracks. We're reviewing innocence claims for potential litigation, and also reviewing them for statistical errors and cognitive bias, not necessarily addressing materiality, but looking for errors in the system and trying to determine them on that level. And that's what Summer is involved with. And then I will be just necessarily determining, after we've assessed the cases for error, determining whether or not they're ripe for innocence litigation. And how we did it was we also are working very closely with the DCI Crime Lab in Iowa. We're in a very unique position, I think, as the State Public Defender, the head of the agency. His name is Adam Gregg, and he's a governor appointee. And together with the director of the Department of Public Safety, where the DCI is under, they're essentially at the same level government-wise. And he was able to respectfully request for a lot of documents that we got with very, very little fight, which I realize is very a unique situation. But we were able to ask for lab reports for every incarcerated person in Iowa that may or may not have used hair evidence. So what we did was we got a list of everybody that's incarcerated and had them, the DCI, look for reports for all of those people to determine whether or not they exist. And DCI pulled every report that even mentioned a hair, whether or not there was any identification made, or whether or not the hair was used, whether they analyzed it at all. They gave us all of those reports because we didn't want them coming to any sort of conclusions at all. We just wanted the reports to be able to come to those conclusions for us. So that's what we got from them, and that's how we essentially started the review. So, is this your?
Yeah.
This is your thing?
Yeah.
Go ahead.
When we were designing this section to talk about developing a protocol for state level reviews, we thought we might go over some of the questions that we asked ourselves when we were putting our protocol together. So it's not going to be prescriptive, but rather hopefully generate some ideas depending on everybody else's particular circumstance in their state or what their goals are. And so the first thing that we wanted to do when we started thinking about tackling Iowa was to set goals and determine parameters. So what questions is our review trying to answer, and which partners are going to need what? We had spoken with some crime labs that mentioned to us that while we're going to the trouble of looking at all of these older cases from this particular era in forensic science, that they could really use information on human factors in their laboratory and different cognitive bias issues and how that might have affected the work of hair analysts or analysts in other disciplines. And they also clued us into this idea that we might want to take a look at the way that other people in the trial were describing the results of the hair analyst's work. So in opening and closing statements, how attorneys might have characterized those findings. Then the second question that we asked ourselves was going to be, what will our process be for gathering documents, and what does that look like? We found that we had great success with DCI and getting the lab reports, and that was super helpful and saved a lot of time and money and effort. Finding transcripts is its own special ball game, and we've had to plan for financing and also for where to start tracking these documents down. So that's a question to gather some facts on before you get started.
I think especially for us, because the lab reports themselves were not very specific at all. Mm-hmm. A lot of the reports were one page that said that there was a hair found in this location, but in, say, a truck. There was no context given as to whose truck it was or whether a hair was found on a sweater, but whose sweater it was. So the lab reports themselves were very, very, very vague. So if there was any inclusion made or any identification or association made within the report, we flagged those for further review because we don't know necessarily where those came from.
Yeah. The next question that we asked is who's going to be making the determination of errors in our review. And as Amelia kind of spelled out earlier in the presentation, the 3 error types identified by the FBI are all rooted in statistics. So we're seeking the help of statisticians not only to help us design the way that we gather information and data in the review, but also to help us make determinations of error. And we're also talking to some cognitive bias and human factors people who may be able to inform us on what we find when we're looking at bench notes, communications, and the type of information that hair analysts might have been subjected to while they were trying to conduct their examinations.
So who will necessarily determine what is actionable and who's available to litigate? I think that's one of the beautiful things about having multiple partners who have different goals. Both of our organizations, as well as the Innocence Project of Iowa, have, I think, historically done a good job of partnering with also private attorneys. So if there's not necessarily an innocence claim, we have attorneys who are able to take these maybe constitutional claims or errors on their face, even when there's no actionable avenue for innocence litigation, that we're able to find a very capable and intelligent partner to be able to take on the cases that we might not necessarily be able to take, even if we've identified that there was an error, especially regarding microscopic hair comparison. And so we will determine together jointly through our review who's able to take what cases, and if neither of our organizations are able to litigate the innocence claim, finding one of our very capable pro bono lawyers who's helped us in the past to be able to take that on. Talking about how defendants are notified, we spent a long time talking about when and if to notify defendants, and we chose, because we realized right away, because we got almost 200 lab reports, that we were going to need to prioritize these cases somehow. So what we decided to do was notify the defendants if we did find that there was some sort of association made, and if there could be a potential for finding an error based on the FBI review. So we chose to notify the defendants at a fairly early stage for a couple of reasons. One of them was to determine what people are saying that they're innocent. And so we chose to send them a questionnaire plus the notification letter, and to have them send back the questionnaire to us, just like we do in every sort of innocence case, asking for more information about the case, what they say happened, and then later we can try to determine, to get documents from them. So those people who returned the questionnaire were the cases that we are currently prioritizing and trying to gather documents for. And that includes additional police reports, transcripts, appellant's briefing, or any sort of post-conviction motion or habeas petition that they have filed in the past to determine what is out there for this case. So we decided to notify them, the first reason, one, to be able to prioritize the cases, and two, to ask for their help in accumulating some of these documents, because the transcripts are very, very expensive. And we were hoping that the defendants would have a lot of these documents, because unfortunately, a very unique, specific situation in Iowa is that there's been a lot of flooding in the past 20 or 30 years in Iowa, and Iowans love to keep things in basements. And there's been a lot of documents that are destroyed because of floods. So we've ran into that
And a lot
problem.
of evidence that's been destroyed too, which makes
Yes.
the review of the testimony all that more critical.
Yes.
in Iowa.
So we were hoping to get some documents, and courthouses kept things in basements also. They also keep courthouses on islands in the middle of rivers that like to flood. But that is a very specific situation in Iowa. So we sent the notification letter with the purpose of trying to get documents from the defendants and hoping that they are available, because they were kept by the inmate or their family, or maybe their prior counsel, to get more information from the inmates themselves about the documents, and to avoid a lot of the work in trying to track them down ourselves and having to pay for copies from either the Court of Appeal, the Supreme Court, or court reporters, which happen to be the most expensive. Let's see. Other way, I think.
So I should say that Midwest Innocence Project is reviewing hair comparison cases with our Iowa partners, but we're also hoping to review cases in Missouri, Kansas, Nebraska, and Arkansas, the other states that we cover. And so we've been really fortunate to get to learn and test out some of our ideals in Iowa. It's been super productive. And one of the things that we think about when we're adapting protocols for each state is to base our time frame, our pool of cases to be reviewed, on lab procedure documents as opposed to just analysts that attended FBI training. And I think that's important for a couple of reasons, mainly because it makes the review about science rather than individual analysts. But when we look at lab protocols, we also get information about what was happening and when at the lab, what was acceptable when, what testimony, how analysts were trained to testify at the time, and the timing that DNA analysis came online at a particular lab could be a good stopping point for the review. But often I think we'll find that labs are still using microscopes to examine hairs, but at this point in time they're doing it as a screening tool to assess hair for potential DNA testing, and not attempting to make an identification or an association with the suspect. So all of that information is really helpful when determining the pool of cases that need to be reviewed.
Talking about Iowa specifically, and I mentioned this really briefly during the introduction, that the DCI lab was provided with all the Department of Corrections data on who is currently incarcerated, and we use that as our kind of closed universe for the lab to search for those individuals' lab reports and then to send us those instead of pulling every single report that was done in the past 30 years or 35 years. So what they did, they pulled the reports in every single case where a hair was even mentioned in the report and then gave those to us. And so we just need to be aware of also, so if we find an error, how are we going to litigate it based on our own state's guidelines, requirements, or post-conviction guidelines? And in Iowa, after the end of litigation within the state court, they have a 3-year statute of limitations to file a post-conviction review, a relief motion, and 3 years is not very long. And it is very, very rare that an inmate has contacted me within that 3 years, and then I'm on a time crunch. And so the new evidence would be a way to get back into court. And then the statute in Iowa, there's been no, well, first of all, there's been no DNA exonerations in Iowa, so we're not quite sure how this is going to work. We're hoping that the discovery of new evidence will restart the 3-year statute of limitations, but we're not quite sure. And in preliminary discussions with the prosecutors there, they intend to raise the timeliness objections for any of these hair cases, but we will see. We'll hopefully use the DOJ argument and, their statement that they are going to be able to waive the statute of limitations argument or timeliness arguments, especially when it comes to hair errors, but that remains to be seen because we haven't quite gotten to that point yet with the cases. So we just need to be, you need to be really aware of how prosecutors in your jurisdiction are going to respond, especially if you are under timeliness. If there are known time limitations for raising these types of claims where you are.
So we're looking at the FBI model as a floor, not a ceiling. We are also reviewing criminal convictions in Iowa, whether they're the result of a plea or a trial. But in this instance, the review is sort of being managed by an Innocence organization and a division of the Public Defender's Office as opposed to a law enforcement organization. So it's a little bit different in that respect. We also see this as an opportunity to understand forensic science a little bit better in the era of the generalist. So when analysts were practicing in a more general way than the sort of specific disciplines they operate in now. And it's a really rich source of information for issues in any comparison discipline that have to do with a lack of statistical underpinning and cognitive bias issues and how they affected or potentially affected analysts back in this pre-DNA era. So we're sticking with the 3 error types identified by the FBI, and to go over them briefly again, they happen when an analyst makes or implies an identification, offers a statistic or a likelihood about an association that they make, or when they use their own experience as a de facto statistic. And as Amelia said, we're using those because they're solid, but also so that we can compare data across states and compare data to what the FBI has found in their review. And we see this as a further opportunity to do a more thorough assessment of all comparison disciplines, and we're not taking that on as of yet, but we think what we learn from studying hair comparisons will have influence on what we find out about ammunition components, fingerprints, tire tracks, footwear impressions, all of those sort of comparison-based disciplines. And we see this kind of from a Sentinel event review approach, that these errors didn't happen in silos. So I think we need to understand how this type of error rate or how this type of erroneous testimony is coming about if we hope to correct it. And I think a big piece of that is understanding the impact of task irrelevant information on subjective comparisons, such as microscopic hair comparisons. So we're looking at all comparisons regardless of limiting language, regardless of whether it's an inculpatory or exculpatory comparison. And we won't make that determination until later, and I think we're relying a lot on Audrey's organization, the Wrongful Conviction Division, to help us assess that portion. So, as I kind of mentioned earlier, some of the places that we're looking at, in addition to the testimony of the analyst, is how the hair is described in opening and closing statements. So we may find situations where the analyst testified fairly conservatively to an association, but the jury may have heard words like match or other identifying terms in the opening statements, and then again at closing, and the subtlety to the limits of what can be said about hair can be totally lost for them in that mix of information. Also, we're looking for human factors, cognitive bias, what order were lab reports completed, what order was the analysis conducted in, if a person was identified at a scene with a fingerprint, was that done before or after their hair comparison, this type of thing. And then what's possible with DNA testing, either on the hair evidence or other concomitant biological evidence. And I'll let you talk a little bit about that, Audrey.
Yes, for some of the lab reports, when the DCI pulled those for me, I also got, often it said that the hair was also sent somewhere for further DNA testing, and then they pulled that report for me also. And so I would review those and determine what year the testing was done. Most of those reports, again, were very, very, very vague, so we flagged those for further review for us, just because it's very hard to tell, based on the lab reports that I received, what type of testing was done, how discriminatory it was, what type of inclusion was made, and if anything, if further testing would result in a more discriminatory conclusion. And so, regardless of whether or not DNA testing was done before, I think only a couple were done in the most recent years. Otherwise, if they were done mostly pre-2005, we still flagged them for further review because DNA testing has advanced so much. Yep. Mm-hmm. Yeah. So we need. Yep. It's back to you.
Oh, okay. It was a page ahead.
Mm-hmm. Sorry.
So our suggestion, and I think this is still a work in progress for us in Iowa, is that once a protocol is developed, to memorialize it with everybody that's working on it so that everybody has a document to refer back to and can kind of stay on track, because this is such a labor-intensive and time-consuming process. And then when a decision is made about where this data will go and how it will live after the review is complete, the experts assessing it, or whoever assesses it, will have a good record about how the review came together and what the goals and priorities were. So, like we've talked about, we're doing our review on 2 separate tracks, with the Wrongful Conviction Division leading the litigation phase and MIP developing a comprehensive review of the scientific and statistical issues.
So I feel like we've developed a pretty strong review team that is still currently being developed. I get a lot of emails from attorneys around the state asking if they can help with the review. Our plan is to train all of them to be able to look for these types of errors, because as you can imagine, reviewing all of these transcripts for the cases that we have flagged that need further review is going to be a very, very labor-intensive task. We found that even finding the transcripts now is problematic at best. So we've recruited a lot of help, and we've developed a good team between us and Summer leading the pack on the statistical review and the scientific errors to be able to have that type of information, and then us looking at it more for once we've determined that an error is made, how that error was used in trial. So we're looking at what went wrong, why, and those are the types of statistics that Summer is going to be compiling to know how these analysts were testifying, what they were testifying to, and how often that was occurring. Because we need, and we're tackling them on both tracks, both the scientific side for the statistical issues, and also for the legal innocence issues. That way we can use them in the future for also other systematic reviews that we might do after this one is complete.
Like Audrey said, we need experts to help us with the things that we're tackling in our review, because we're not statisticians, we're scientists. So we know from the FBI that these errors are rooted in a lack of statistical framework. There weren't random and representative population data studied to see how often these microscopic characteristics occurred, and we really have no way of knowing how often 2 people's hair looks the same microscopically. And so for that reason, we need statisticians to help us and cognitive bias experts to help us for the other parts of our review, but also we need their help in designing the review so that when we ask experts to review testimony, they aren't subjected themselves to task irrelevant information. So we're relying on a lot of smart people to help us. We feel like the 2 elements that are most essential are lab reports and trial transcripts. And Amelia, correct me if I'm wrong, but I think that's the same as the FBI review. Is that correct?
Yeah, we don't consider opening and closing statements in the FBI review.
But you are using those 2 documents as your main source of data?
Yep.
So the errors live in the words that the analysts use to describe their conclusions, and the way that other people, either officers or attorneys, used words to describe the conclusions that hair analysts came to. So I think it took us a while to kind of comprehend the different nuances in the error types, and we were fortunate enough at MIP to have some cases on our waiting list with hair comparisons in them, so we were able to dive right in and familiarize ourselves with how that looks in testimony and things like that. So we got to do a little bit of a pilot study to train ourselves to begin with. You want to talk about prioritization?
So we needed to figure out a way, instead of, tackling these cases alphabetically, prioritizing them based on need and to kind of help guide us in this undertaking. So we were prioritizing cases based on determining, one, if the defendant's still incarcerated, because that's where we got the list of reports for DCI to pull, and whether or not they have an innocence claim. So every person whose lab report that I got and that I have determined that they need further review, meaning that there was some sort of hair comparison made in their case, whether or not they're claiming innocence, because we wanted to be able to prioritize those and at least have kind of front runners to try to get those folks out if possible first. And of course, we want to review every single one of the cases that need further review, but we wanted to kind of give ourselves
A starting place.
exactly of cases to review.
We are referring back to our wonderful experts again to help us design the mechanics of our review for information gathering and storing and coding. That kind of ties into what you're doing when you look at a case to see what the potentials are for litigation. But I think the last step that we've gotten to is figuring out how to organize our information in such a way that others can use it, either to study forensic science, to study what happened with hair, or to prepare to litigate cases. So we're hoping that our review documents can serve all three of those purposes.
Yeah. I think that's about it for Iowa-specific information.
Okay. So the next kind of hurdle in the state review process is notification. And we've talked a little bit about this throughout, but I just want to hit on the idea of meaningful notification. When we say notification, we don't mean just sending out a press release and hoping that it makes its way into a prison and someone who was convicted based on this flawed testimony hears it. In order for the review to mean anything, the notification has to be meaningful. So that means that you have to really explain to the defendant what happened in their case and why. Be sure that they know what the review means, what the results were, and what their options are. So I think things to think about at the notification stage is who you're going to notify. As I mentioned before, the DOJ does not send notifications directly to defendants unless they have no other option. However, in your state, it might make a lot of sense to communicate directly with the defendant for the reasons we've talked about before. They have access to the information and they know best what happened in their case. Instead, the Department of Justice just sends the notification to the prosecutor and the last known defense counsel on a very specific timeline. And then think about how you're going to notify the defendants whose cases have been reviewed. We think that it's best if the notification comes from the lab or the state, if possible. But if not, then being sure that you're representing yourselves appropriately in that communication, and also be cognizant of the language you use and who the audience is. And there's a lot of concern sometimes about communicating with defendants that you might establish an attorney-client relationship without meaning to. So being sure that you are making it clear what you're doing when you look in their case. If you need them to sign a limited representation agreement, doing that as well when you communicate with them. Be mindful of co-defendants when sending out notifications. We try to send them, it's sort of random how it comes through the review, but it would be ideal, if those people are notified at the same time. And then it's a good practice to maintain one point of contact so that, once these letters start going out, there's going to be a huge response. There's, obviously, if you've been sitting in prison for many years, you're going to be really excited to hear that someone is looking into your case. So it's good to have one consistent point of contact within your partnership or organization. And then think about when you will notify. In Iowa, they notified on the early side. We only notify after the review is complete. And the way that it's structured, the state will know before the defendant will know. So you can think about the best way to do that in your own your own state. And then remember, as Audrey mentioned, and is always important, that notification probably starts a clock on a newly discovered evidence claim. So that's one thing to think about when thinking about when to time your notification. If you communicate that there might be a problem before you've done the review, you should think about whether or not that will start the clock. Just be sure that you're working within the timeline of your state, depending on your state post-conviction or habeas statute. And then just finally, we've talked about representation a lot throughout, but I think how you think about this problem, how you construct your review depends on what the goals are. Is your goal just merely to notify that a problem happened, or is the goal to review and then to correct the problem? Obviously, attorneys are important in both scenarios, but even more important if the review is going to lead to litigation. So construct your review around that goal and around, kind of what you hope to get out of it. And then, again, back to materiality. Although we strongly discourage you to consider materiality during the review stage, if you don't do that, it does make it harder to find counsel at the end. At some point, someone's going to have to analyze the impact of the error on the conviction, and that's just something you might want to plan for, maybe in a second stage of review, or maybe in two parallel tracks, like in Iowa, or just with partners in post-conviction counsel, pro bono counsel. And then finally, recruiting pro bono counsel. It's a great idea to partner with a law firm like Ropes and Gray if you can, a public defender organization if you can, just someone with the resources to do some of the representation work when this is all said and done. If you're interested in partnering with an NACDL affiliate in the state, I'm happy to connect you with those people. It's a great idea just to get to bring to the table someone with a wide list of resources for for attracting pro bono attorneys. We found that there's a lot of interest early on, and then the longer the review progresses, interest sort of wanes. So being sure you have a good pool of post-conviction attorneys at all stages is really important. And then finally, thinking beyond representation, obviously, getting someone out of prison for a crime they didn't commit is an amazing goal, but there are goals beyond overturning convictions that we can think about in this context. These reviews, as you can see, are a really great way to form relationships with the lab, with the prosecutor in your state, to work in a really different way with people you kind of come head to head with a lot in other contexts. That can lead to a lot of goodwill and good relationships. It's also, a good excuse to look at your state DNA testing statute to expand evidence preservation and collection in your state, to establish a forensic science commission, or to review other forensic sciences, be it serology or latent fingerprints, bite marks, tire tread. Really, the list is pretty endless, unfortunately. It can provide a good framework for looking at other flawed forensics. And it might be a way to look at your post-conviction law to make sure there's a way back into court beyond just newly discovered evidence for flawed forensics, people who have cases are tainted by flawed forensics that develops later, to get back into court and not be barred at that point. So that is all for our presentation. I have a couple questions, and I don't know if we have any questions. We can go through there, and feel free to email Vanessa right now if you have questions.
We did have one question about the format you all were talking about in Iowa, and that was who ultimately handles the cases. I know you said there's a track for people with a good innocence claim, but there was just a question about whether the public defender ends up handling those cases, or whether, as Amelia was saying, volunteer lawyers are recruited.
Yeah, the primary person would be myself at the state public defender. We do have a plan for cases where there's conflicts, or if there are co-defendants, to allow for either MIP to then take that case, or recruit or use one of our pro bono counsel to be able to take those type of cases. But the plan is for the wrongful conviction division, meaning myself, to take the majority of cases, barring any sort of conflict situation or
Which will
something
come
like that.
up
Yeah.
when looking at a huge pool of cases like this. So it's good that you were leading the way on that.
Yeah, thanks.
And the other question, I'll just phrase it kind of generally. Other than what you described about the experience in Iowa with a prosecutor not waiving, have you all heard about other instances of whether or not people, I know Ira, you probably have experience, will or will not waive procedural bars in the states?
My experience is that generally that's their first argument to get a case thrown out, is some sort of procedural or timeliness bar before even having to litigate on the merits.
I mean, generally speaking, about hair comparison and serology, we haven't gotten there yet because we're still getting the information. Massachusetts is a little different. Our post-conviction collateral review law, so to speak, is a little bit more of a lower bar. So
Okay.
the timeliness issue comes up only if we'd raised it before or didn't raise it when we could have, and that's not the issue here.
Okay, thank you.
So I just had a couple of questions that came up for me as I was listening to you guys speak. I was wondering if you could speak to your experience trying to get the lab to the table, and if you have any advice for what resonates with labs when you're trying to get them on board with this this type of project.
For us, it wasn't a huge having to sell them on it. I think the FBI's findings is a very good way for them to kind of save face and help and recognize that there's a great potential for an error. 95% is a high number. So getting them to assist in that review and at least cooperate in getting us lab reports is kind of the least that they can do to try to correct these errors if they did occur. And we made it clear that we were not assuming any sort of misconduct or anything like that. They were being trained and testifying to what they believed was true, even though it was not. So that was kind of our experience.
I can ask the question again.
If you have any advice for what resonates with labs to get them to the table.
Well, I think as I just said earlier in part of the review, we tried to, we strived hard to take off our adversarial hat, which as public defenders and as criminal defense attorneys is not an easy thing to do, but to approach it with an open mind that the people that work at the laboratory, are scientists and are doing scientific tests, and that even in Massachusetts, like many states where they're housed within sort of a law enforcement mechanism, they may still have that perspective as well. But we sort of wanted to hear the conversation, like what would it take for them to do this review, and we were surprised. I mean, the lab wants to show that it's a credible institution. And if you give them the space for that, I think that they can really be on board. I think some people that I've heard from have had difficulty because they've come at it sort of too hard from a litigation standpoint, too fast, as opposed to a collaboration standpoint, if that works in your state.
Could I jump in and kind of echo what you were saying, Ira? I think that the labs that we've been talking to in the Midwest anyway, they already know that they need to do this, in part because of the FBI review, but also because of what AskCloud Labs told them. And one thing that we've heard sort of conversationally from different lab folks is we never hear from the defense. And so I think that there is potential there for a more collegial relationship, but for whatever reason we've sort of kept our distance and not being a lawyer. I don't know if you all have more insight into that. But one thing that we found to be good going into conversations with labs is to be prepared for their first concern to be resources. So the staff time that it takes to go down to wherever the paper files are kept and go through each sheet of paper to try to find the information we're asking them for is intense, with their caseload being what it is. So I think if I had a suggestion, it would be think about what resources could be applied for or brought to the table, so that that doesn't become that doesn't become an excuse or a hurdle.
Yeah, great. And then I think in conversations with I've had with people who want to start this kind of review, they've litigated cases in their state involving hair comparison. They know there's a problem, but the idea of undertaking this huge project is really daunting. I was wondering if you had some advice for people who are just at the very beginning point. They just, where you were a year or 2 years ago. This is something they want to do, but they don't know how to get started. If you have some advice for those folks.
I think doing it as one person would be extremely daunting.
Mm-hmm.
I think the thing is, if you have partners that you can work with, I think it makes it a lot more manageable task, and knowing that these cases need to be worked on, and taking it one case at a time. You can only do what you can do, and recruiting meaningful partners, I think, is super advantageous, because if it's one person that just realizes that there's an error and wants to look at, hundreds of cases, that obviously would be really daunting. But I think finding a meaningful group of people to work with, whether that's a state public defender or an Innocence project or
Clinic at a law school.
Yeah.
A law school clinic, that's a great idea.
The lab itself.
Law students are great because we generally don't pay them. So, and then it's not a funding issue either. Yeah.
I mean, I would also just sort of echo. I'm sorry, someone was cutting. No, I would also just sort of echo, like, don't. As I hope you understand now, at the end of this, you're not inventing the wheel. You can reach out to NACDL. You can most likely reach out to your state level affiliate of NACDL. You can reach out to any of us, certainly. But there's groundwork that's laid for the ways to think about that. But I also, I guess on a more organic level, don't think that you have to have all the questions answered to move forward, because one, that no one does, and two, you don't have to have everything mapped out, how everything's going to look, because you won't know what the information will look like anyway until you get it. You just need to know what some of your steps going forward are.
I think that's really good advice.
Yeah, and these things take a really long time. It took us a year to get up and running, and we had the resources of the federal government behind us. So, any more questions?
Is this on? Apparently it is on. I have a question for Amelia. Amelia, is it true that there's a group you can sign up with on NACDL Connect to get information about microscopic hair comparison?
That is an astute question, Vanessa.
Is that a question from the emails?
Or
Yeah.
listener.
Yes.
That is an astute question, listener. Yes, there is an amazing group you can sign up for at, you'll see on your screen, www.nacdl.org/hair comparison. Scroll down a little bit on the page, and there's a link to log in to sign up for our NACDL Connect group. You don't have to be an NACDL member to join. It's called Hair Comparison Litigation Group, but we talk about state reviews in there as well. We hope you will join us, and if you have any trouble with that process, feel free to email or call me.
Yeah. And it was just great for Amelia to set that up, because in terms of people trying to organize a review in their own state or just get involved, hopefully people can talk to each other. There are other states out there doing active reviews. I know North Carolina and the North Carolina Innocence Project, Chris Muma, I'm sure, would be a good resource, and other folks out there. So I just thought I'd toss in a plug for the good work of setting up a great listserv.
Yeah.
Awesome.
Anything else? Well, we're done a little bit early. Thank you for joining us, and feel free to contact any of us with any questions, and visit nacdl.org/hair comparison for more information. Thank you.
Thank you.